Right now, companies are using your personal data without your knowledge, and most people have no idea they have the legal power to stop it, demand it back, and force companies to pay for it. In 2025 alone, regulators issued over 1.2 billion euros in data privacy fines globally. The FTC finalized an enforcement order against General Motors in early 2026 after the company sold granular driver location data to third parties without clear consumer consent. Disney paid $10 million to settle FTC allegations of collecting children's data illegally. And California's Privacy Protection Agency currently has hundreds of active investigations running right now. New comprehensive privacy laws took effect in Kentucky, Rhode Island, and Indiana on January 1, 2026. The enforcement wave is accelerating. But here is what nobody tells you. Consumers already have powerful rights baked into these laws. Most people just don't know how to use them. Under the California Consumer Privacy Act, the CCPA, every consumer has the legal right to request a full disclosure of what personal information a company has collected about them, what categories it falls into, and which third parties it was shared with. This is called a data access request. Businesses have 45 days to respond. They can extend by an additional 45 days only if they notify you in writing first. If they ignore your request entirely, that is a violation. Under the 2025 CCPA fine structure, intentional violations carry penalties of up to $7,988 per incident. Important note, these rights typically apply to companies with over $25 million in annual revenue, or those processing data on over 100,000 consumers. Your action step: go to any major company's privacy policy page, find the Submit a Data Request link, and send your request today. Every qualifying company operating in the U.S. is legally required to have one. Once you know what a company has, you have the right to demand they delete it, not just from their own servers, but from every service provider in third party they shared it with. The company must confirm deletion in writing. By 2026, over 15 states now enforce this right, including California, Colorado, Connecticut, Delaware, New Hampshire, and New Jersey. New Jersey's law carries fines of $10,000 for a first offense and $20,000 for repeat violations. One important distinction: Indiana's new 2026 law is active, but it still carries a 30-day cure period, meaning companies get a warning before the fine hits. Your action step: submit a deletion request through the company's privacy portal and take a screenshot with the date and time. That screenshot is your legal evidence. Companies do not need your permission to collect your data in most states, but they are legally required to honor your request to stop selling it. As of 2026, California, Colorado, Connecticut, and Oregon now require companies to recognize the Global Privacy Control Signal, a free browser setting that automatically communicates your opt-out preference to every website you visit. Bonus tip: if you use Brave or DuckDuckGo as your browser, this signal is already turned on by default. You were already protected. Healthline Media was fined $1.55 million in July 2025 for failing to honor this signal and for sharing sensitive health browsing data without consent. Your action step: search Global Privacy Control browser extension, install it for free, and activate it. It is now legally enforceable in multiple states. If a company fails to protect your data and it is exposed in a breach, California law grants you a private right of action, meaning you can sue directly without waiting for a regulator to act first. Statutory damages now range from $107 to $799 per incident, updated for inflation under the 2025 CCPA adjustments. Multiplied across thousands of affected consumers, companies have paid millions. The FTC also accepts consumer complaints directly at reportfraud.ftc.gov. Every complaint feeds directly into enforcement databases used by active investigators. Your action step: if you have received a data breach notification, document the notification date, what data was exposed, and when you originally signed up with that company. That record is your legal foundation. Here's the larger trend nobody is talking about. The cure period is ending across the country. California already eliminated its mandatory 30-day grace period entirely. Rhode Island's 2026 law launched with zero cure period from day one. Indiana still offers 30 days, but that window is closing industry-wide. Regulators are no longer warning businesses, they are fining them immediately. If you did not know you had any of these rights before this video, that is exactly why Clear Rights exists. Every week, we break down the laws that affect your money, your business, and your data in plain English. Follow Clear Rights so you never get caught off guard again.